exceptionally fulsome decision from the court in which he found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this. Under Rule 13, and under Commonwealth versus De Los Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case, if the matter was not raised, it's considered waived. So tell me why, and I understand the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues aren't waived under De Los Santos and Rule 13.
Was there another issue, Your Honor, you wanted me to focus on?
No, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in a grand jury transcript and motions that were ruled upon by Judge Doolin. That is correct. And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings. And as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
Well, it's not really form over substance. It's substantive. Rule 13 is substantive. De Los Santos is substantive. And there's a reason for that. And the Commonwealth in their opposition has pointed it out. It's because you can't keep retilling the same ground over and over and over. At some point, you got to move forward. So it's not just form over substance. So you got to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does at the court's discretion. Right. But you got to have a reason. Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees prejudice, the court respectfully should act. Now, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling. Which presumes that Judge Doolin was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know. Well, the actual videos that were presented to the grand jury, Your Honor, were 40-second snippets of hours-long video, which were not grand jury exhibits. So respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello... And
he watched the clips, no doubt.
Yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Kearney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Doolin referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names. Names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is Everybody sees it. Everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Kearney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Kearney's intent are contained in the actual videos. And what you have at this point, it's very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing counts in this case are from this so-called rolling rally. That entire video, the whole rally was recorded, video recorded by Mr. Kearney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally Justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent, literally. And he did that approximately 30 times throughout this proceeding, told the grand jury, this is proof of his intent. They literally asked questions and answers that talked about intent. They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why, what prosecutor?
But their allegation is that is the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They were alleging those clips are the intimidation.
Right. But, Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5. So we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of.
But a police report and a video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips. But
they didn't tell the grand jury it's available for you. The point is they told the grand jury the name of the video is Jury Influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after DA Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that. And this is in August of 2023, well before trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way, to say, literally, Your Honor, I can read to you there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully before he plays all of these videos, which are misnamed, cherry-picked. Do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again through direct intentional questioning of Mello, it's not volunteered, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
Yeah, but slow down, Mr. Petro. You have to give the grand jury some credit. The grand jury understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created it.
That's my point.
Right, but give the grand jury some credit. They understand that.
Your Honor, the point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed, or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us. I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion, Bleakney, the appeals court case, not the SJC, the lower appeals court, where they cherry-picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
if you're going to go there, Mr. Better, if you're going to go there, then you got to talk to me about Shaquille Brown.
Shaquille O'Neal?
Which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the
yes, sir.
Slow down. This is the difficulty that you have. So this is why De Los Santos does matter, and it is substantive. Okay, this is why Rule 13 is substantive, because you already had a very thoughtful, all right, a bulwark, if you will, from a judge. All right, a very thoughtful judge who examined in detail the entirety of the grand jury, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the site if you like.
I have
490, 171, and I'm very familiar with that case. All right. In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, and this is why De Los Santos is substantive, because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent. Oh, he is
but in Brown, they're trying to show joint venture, and they dump in prison records they haven't even read.
Judge, I'm bringing it to this case, okay?
Yeah, but this is the SJC telling you this.
I understand that, but the facts here matter, and the context matters. And just because the prosecution has, a one-sentence explanation of what they say, and a grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier, context is everything. If there is a long statement that is talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective,
grand jury's not really,
fact finder.
grand jury's not really fact finder. Grand jury is more of a gatekeeper. But go on.
But they have to, Judge, respectfully, they're not. They have to find the facts to support an indictment. And in this case, they literally did, but they were misled, and context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly. And they put their finger on the scales with evidence of his intent in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. Judge, the last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense. If anyone's prosecuted these cases and put in cases in the grand jury, that makes no sense. That's the crime. Give it to them. But what they did was they tried to suggest that he was harassing and intimidating the O'Keefes, who were not even charged victims in this case. That's how they finished the grand jury. That is clearly a design to prejudice, to smear. They put in evidence of an uncharged wiretapping and read the statute that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But a judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand jury. I'm going to answer the questions that obviously you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why. Well,
I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. I mean, the whole point. But before I get to the merits of that, that motion would have been made anyway. So that, I mean, because we can't make a motion based on evidence of which we're unaware, obviously. And at that point, if you're making a motion to dismiss for extreme government misconduct, there's no reason why the court should not consider as a facet of the misconduct that occurred in this case what occurred in the grand jury before. Now, as far as the Peter stuff, which I don't want to beat to death, and most of it is in the papers, the point is all of that evidence should have been disclosed in early 2024, which was we're closing the deadline for discovery. That material didn't come anywhere near that timeline. It came in July of 2025 after numerous specific, very specific Brady demands and Discovery Rule 14 demands. They could not have been more specific.
So let me understand, what is the basis that you're asking me to dismiss? Is it for the discovery violations or for the substantive violations?
Well, it's for everything. Oh. On the second component of the motion, the indictments ought to be dismissed based on the impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time, and the court should consider that in even hearing the grand jury component of it. But in any event, if the court is wondering why, if discovery was ordered to be completed in early 2024 and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peters may be something which is outside the Rule 13 and the De Los Santos analysis. So I'll give you I'll give you an open field to discuss that.
Okay. Excuse me, Judge.
Yes.
The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. There is a strong argument that could be put forth if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Not only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute. It's in the motion. Has forged court filings to try to screw him in part of their fighting during their life. Has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she, in fact, defamed them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control. It ought to have been turned over. And what was contained, we don't know. But you know, there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now, Tully says, I never opened it, and now the links are gone. And we were told in filings, you know, it's been dismissed, it's been deleted by a third party, which presumably is Peter. And what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him and
commits fraud? Isn't the shoddy work that he never opened them?
What's that?
Isn't the shoddy work that he never opened them?
That's amongst other things. But I had said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted in all the time the prosecution had to respond to the motion. And if the court remembers, they got many graces in deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, you know, this is what it would be. That's not evidence in response. What was required is something from Mello under oath, and we've never gotten that. And that's very important too, Your Honor. One of the things that we asked for in the motion is, as an alternative, a hearing, okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
How does this affect the grand jury presentation?
Well, Peter,
I just want to see the argument. I'm not.
As far as the grand jury goes,
Sure. Yeah.
it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
But according to Tully, he doesn't open it. So I'm just trying to. You may have a separate argument. I'm not saying you don't. Okay, as to what the relationship between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell, or is this some separate motion?
It's a suppression motion, goddammit.
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
But I got to understand what that hybrid is,
Right.
counsel. Like, because
No,
you give me kind of a mishmash here with all sorts of stuff in it, and I'm trying to sort it out.
This is what happens when
Judge,
you're
there's a standalone Odell motion, clearly, about impairing the integrity of the grand jury proceeding. We also filed...
But how does... Go on, I'm listening.
There is a second motion to dismiss for extreme and egregious government misconduct based upon... beats me a separate motion to dismiss based on what you filed, Mr. Betteroff. No, Judge, it's a second point.
All right, this is the problem with what you filed, but we've discussed that already. I can't discern that there's a second motion to dismiss. Here it looks like a big Odell.
Judge, we don't know what missing evidence we didn't get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't, and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled Intent.
Whoa.
That may very, we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says, I never looked at it. Mello is unheard of. He's just disappeared in the wind. There's no sworn statement from him.
It doesn't matter.
These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
Well, I'm going to need a better motion than what I got in order to do that. But Mr. Cosgrove, what do you got to tell me?
I need a better motion.
Just go through it. Sure.
He's like,
What you think is important?
I spent a year on that.
First, whenever I hear counsel use the word cherry-picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said and did and put on the air.
Well, why not give them the whole video?
I'm sorry?
Why not give them the whole video? To go to Mr. Betteroff's point, why not give them the whole video to watch and play them selected clips, as is often the case?
I don't know what the reasoning was at the time, Your Honor, but if you look at the chart that Mr. Betteroff includes in his motion, or his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever, it could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes, and the Commonwealth introduced this, and then they didn't indict him with respect to intimidation of the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mello had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in, and that the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context, and if only there was the context, if only the whole thing had been shown. The defense has read my response and said, Your Honor, and one of the things I said was, where is it? Where's the submission to the court? These are the things that if only the grand jury had viewed them, as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, it would have put things in a completely different light, and here's why. You don't have any of that. There may be some things in the entire videos that for example, Mr. Betterow says at one point, Mr. Kearney talks about how he's going to expose corruption or something like that. Or Mr. Kearney could have 16 different motives. People have more than one reason for doing things, for putting something in. Some of those motives may be good motives. But those motives are irrelevant. All the Commonwealth has to prove is that one of his motives was to intimidate those witnesses. That's what's relevant.
Boom.
Furthermore, I think, as Your Honor alluded to, we can infer a certain degree of sophistication on the part of the grand jury. Nobody watches even the evening news and sees a snippet of a Trump press conference or something going on in the city of Boston or an excerpt from what's going on in court and leaves under the delusion that other things weren't said, other things weren't happening. They understand that the news media selected what they considered relevant and showed that. In fact, I think that's what Mr. Kearney does on his own broadcasts. People are sophisticated based on years of watching news shows and years of, at this point, watching the internet. There's nothing to stop a member of the grand jury, and for each of these witnesses, grand jurors had an opportunity to ask questions. And if you've read the grand jury transcripts, you know they did ask questions, and they certainly could have said, you know, you're only showing us a snippet here. We'd like to see the whole video. Nobody did that.
Are we going to put this on the grand jury to make sure they get a square presentation?
No, I don't think we're putting it on the grand jury. I'm simply pointing out that in addition to the other points I've made, the opportunity was there. Nothing was being concealed. I think the practicalities of presenting the grand jury with however many hours it would have been, 26, 46, however, these shows of Mr. Kearney's run about 2.5 hours, would be somewhat absurd, frankly. I think the Commonwealth's obligation was to show what was relevant, and that was what we did.
Okay. Tell me about the issue, your thoughts on the issue with Ms. Peters and Mr. Mello.
All right. With respect to Ms. Peters, I want to make a couple of points. One is Mr. Betterow raises this issue of the prior federal court suit, which Ms. Peters apparently admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there is no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People went and looked at the broadcasts that they were pointed to, why they would go back and screen for federal court cases to see if the witness had previously been involved in a federal court case. I don't know. It's not a search warrant where you're trying to establish the veracity of the informant, and maybe you do some research in that case, although I think it would be rare that that kind of research would be done. So the suggestion that the Commonwealth knew or should have known that this witness was tainted in that respect, I think is somewhat absurd.
To the best of your knowledge, were any of the Peters materials presented to the grand jury?
The Peters materials were presented to the grand jury in the sense that there were a couple of audio recordings that were obtained from
Steve Scanlon.
Kate Peters, which Lieutenant Tully could not find checking independently because the theory was that Mr. Kearney had taken them down and had replaced them with different videos in which he had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those.
This went to the wiretap indictment, which didn't happen.
Right. So those are the only two. The rest of the.
How is that? How did he not get charged with tampering with evidence, obstruction of? I mean, what the fuck? That is like accessory after the fact for himself.
Whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who were obviously not happy with some of Mr. Kearney's broadcasts about them, or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that representation, and presented them to the grand jury. And I would point out to Your Honor, to this moment, there has been no representation that any portion of the videos that the Commonwealth showed, which we presented to the grand jury as things that Mr. Kearney himself had recorded and broadcast, were not genuine. There's only been this argument that, well, they were taken out of context. If they saw something else, the jury might have thought something different.
Was the grand jury, I should maybe know this. Were the wiretap indictments no billed, or were they withdrawn?
They just, withdrawn.
Neither.
We didn't proceed, well, on.
Or did they not ask for a vote, actually, is a better way to put it.
Well, on the Gaetani wiretap indictments, those were issued, but that complaint was.
Yeah, I'm not worried about that.
So that leaves us with the Scanlon presentation. And what happened was, after the presentation was made, an issue was raised in the mind of an issue was raised with the prosecutor as to whether, in fact, a Norfolk County grand jury would have jurisdiction. Mr. Scanlon having been, I believe, in Suffolk County for his end of the conversation, and I believe Mr. Kearney was not in Norfolk County at the time either. So there was some thought that maybe, as I understand it, maybe that Mr. Mello would ask Mr. Morrissey to get himself appointed as a special prosecutor for Suffolk County for the purpose of seeking an indictment there and joining it. But it was never pursued. With that in mind, the Norfolk County grand jury just expired without anything further being done. So nobody ever went in front of the grand jury and said, this is withdrawn, but at the same time, no true bill was proposed to the grand jury relative to Mr. Scanlon.
You just never asked for a vote on it.
Never asked for a vote.
Any more you want to tell me?
No, I'm content to rest on my memorandum unless Your Honor has questions.
Mr. Betterow, I want to go back to this Peters thing, because I'm struggling to understand exactly what your basis on the Peters evidence is. It is a loss of exculpatory evidence? Is it, I don't know, you tell me, because again, The motion comes in as an Odell McCarthy, sort of, and then goes on for many, many paragraphs, but never really tells me much about why this is important. So is it an Odell, or is it a Commonwealth versus Willie loss of exculpatory evidence? I gotta know.
We don't know what Peter evidence ended up before the grand jury because nobody seems to have it. What I can tell the court is she provided a copy of a Scanlon alleged illegally wiretap call.
Which isn't part of this indictment.
No, but to get to the point where they just said on the Scanlon evidence, we just never asked for a vote. What they never did is what every prosecutor should have done, which is instruct the grand jury, disregard that. They didn't do that. I mean, that kind of just slipped by in that exchange that was just had. You put forth uncharged crimes of wiretapping and actually tell the grand jury this is punishable by up to 5 years in prison for whatever reason. It doesn't matter. You choose because you think there's no jurisdiction or not. What Mello was obligated to do as the legal advisor to the grand jury with a duty of fair dealing, not to be an advocate, but a fair and honest broker, was to tell the grand jury, you must not consider any of that. You should not consider that evidence. You should not consider any possible penalty. So where did that come from her? We don't know. We also know that she sent evidence to Tully and I believe also Mello saying, I have taken clips from videos which show his intent in a folder named intent. We don't know where that came.
Let me try to separate this out because I'm trying to understand your argument and be very fair to you, okay? It doesn't sound like there's any argument here there's a loss of exculpatory evidence.
Correct.
All right, so we can take that off the table, right?
Yes.
Is that a yes or a no?
Yes.
All right, so I don't need to worry about that. So what I'm now left with is the argument that the information, the only information that we seem to have right now with regard to Peters is the Scanlon non-indictment, right?
No.
Does that seem about right?
And sending clips from videos in some folder named intent to Tully. That as well.
But we don't know that any of that got in front of a grand jury.
We do not know if that's literally what he used. Correct.
Right. So what we do know is that the Scanlon information got to the grand jury.
We believe so. I mean, I can't tell you if they took her version and found
But we know there was testimony about that or evidence about that.
There was testimony of that uncharged crime that was
now
left there.
I'm really trying to hone down your argument, something I can get my hands around. All right. Now what we're left with is the question of whether or not the grand jury was, under Brown, tainted by the inclusion of that evidence. It's a high standard, really difficult, given Judge Doolin's findings already. Or whether or not Mello had an obligation to instruct the jury on the law about that now withdrawn or not pursued indictment. Does that summarize the argument?
It does, and Your Honor, I can't fathom a world in which a prosecutor...
I'm just trying to make sure I understand the argument. I don't need further argument on it. I'm just trying to figure out if that's the argument.
Of course, he should have instructed the grand jury to disregard prejudicial uncharged crimes, which could result in somebody going to prison. Yes.
But I still have to go back to the Brown issue of whether or not it affected the integrity of the grand jury.
You have to determine whether it affected the integrity and ultimately whether it mattered. And, in terms of, did it probably influence the grand jury, the Mayfield standard, something else the court should consider about whether any of this matters. In March of 2024, Mr. Mello took another shot at a grand jury involving Mr. Kearney and Karen Reed for essentially...
But not this grand jury.
No, but...
All right, then we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence, and that case was no build.
That's a whole different ball of wax.
Oh my God!
The point is, could it have influenced? We don't know.
I'm not going to guess about the grand jury presentment that I've never read, I've never seen, and involves a far different set of facts than this. All right?
Yeah,
whatever, I don't know the details of what happened or didn't happen between Mr. Kearney and Ms. Reed. I don't know and frankly don't care. Okay? What I care about is this grand jury, okay? In much of that communication back and forth, allegedly with Reed, allegedly between him, it's not before me. I'm not going to draw an inference from that. I can't. You know that.
I'm not asking you to. It's the same video.
You just did kind of.
No, Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things. And admittedly,
I'm going to guess there was a whole lot more to that grand jury than these videos.
Not much.
Whatever. It's not what I'm not before
Understood.
me. I'm not reviewing it. I don't have access to it, so I can't draw a conclusion as to whether or not how it compares. So that's, believe me, the last place I want to go down the road is figure out any interaction between your client and Karen Reed. That's got no part of this trial. All right, not fair to anybody. Okay. All right.
They should.
Anything else you want to tell me about this?
One other just response to something Mr. Cosgrove said, and when the court was asking him, why not just play or give the grand jury the opportunity, if they so choose, to have the videos, and the response was, well, they could have asked. I didn't
put a lot of stock in that, so I wouldn't spend any time on that.
Whatever they don't know, and the last point, Your Honor, is why rename the videos? Why say it comes from the intent? Why offer the opinions? It's to put their finger on the scale and to say, we believe he did it, you should believe he did it, and that's improper for a prosecutor to do as a legal advisor to a grand jury.
Fair enough. All right, I'll take it under advisement.
Two quick points.
Sure. Yep.
I just want to point out that from the Commonwealth perspective, the whole Scanlon argument is waived because they had the grand jury minutes at the time that they brought the last motion, including
the Scanlon argument, it limited to the idea that they should have instructed.
Right.
Okay.
Right. The second point I want to make is the argument that they don't know what information came from Ms. Peters. I guess my response is, doesn't matter. It doesn't matter that she has an animus against Mr. Kearney, that the two of them are oil and water.
Irrelevant.
Doesn't matter if the Commonwealth kept those videos from Jack the Ripper or whether the Commonwealth kept them from St. Teresa. The question is the video evidence authentic? And it is.
Okay. All right. Enough on that. Next issue. Do we have the third party here?
Yes, sir. Yes.
All right. From the defense, I didn't get a response or an opposition. Is there a response or opposition?
No opposition, Your Honor.
So you're fine with releasing these matters?
Judge, we're, from our perspective, this is all out in the possession of the internet, if you will, and it seems like everybody has it and can look at it except Mr. Kearney, but that's another issue for another day.
Well, we returned it to him, did we not? That was the order that
I know. You're gonna go off?
me to
Okay,
do.
hold on.
Yes, Your Honor, but it's there's all sorts of.
Okay, just a sec.
Okay, whoever's on the video, you need to shut down.
You dumb bitch.
I muted him, Judge.
And further, Your Honor, Mr. Kearney provided Attorney Diller with all these communications.
So this is not an issue? Because my intent, frankly, my first impression here is I want to protect Mr. Kearney's rights not to have these investigatory materials released. But if you're okay with it, I'm not going to stand in your way.
I appreciate that, and if you're inclined to do that, I certainly would ask you to do it.
Well, you didn't. That's why I asked you if you opposed it, and you said no. So
But if that's your inclination, or any layer of protection we appreciate. But unfortunately, this is out on the internet. Number one,
Because of
he's given it to Mr. Diller as a pro se, non-party deponent.
So what do you need it from Mr. Diller? Why do you need it from me if you already have it?
I don't know that I have it. I know that I just got a link from Mr. Kearney a couple days ago because I went into our case and also got a motion to compel, which was allowed.
Okay, let me explain what's happening right here. Dillard's there because Aidan Kearney had to get that shit to him and fill out, he was subpoenaed and you have to get us this material. And Dillard wants to know, like, okay, just because you're giving me this like link, I want what the courts have, because I basically go fuck yourself. I don't even know what this is.
Loud. So I'm entitled to at least compare the two matters to see whether they are consistent in that it's comprehensive. I appreciate.
Why isn't this before Judge Gilday, not me?
It was before Judge Gilday, and he issued an order. There's a separate issue, which is we've executed a protective order, and any of the materials that will be provided from this case to us will be protected. There's also been a Gilday order that there's no dissemination or discussion of any of the confidential information. So there will be no leaks of data into the world, and this case will come to judgment prior to the O'Keefe case. So we've asked that we get access to those materials. We know that they are the authentic materials, and we request we'll execute the protective order, as will the other parties who do not object in the O'Keefe matter. Will all execute the same confidentiality protective order, and it'll be used exclusively in that case.
For the record, let's get your name, sir.
Attorney Mark Diller on behalf of the O'Keefe family.
Thank you. Okay. Anything further? Anybody want to be heard on this?
I don't have any objection to providing Mr. Diller with a copy of the same materials that I believe are already out there on the internet. Ironically, have been released not by Mr. Kearney personally, but through someone who was associated with him, as I understand it. The problem that I'm dealing with is
There's Judge Krupp's protective order.
is essentially found on Exhibit B to the motion to intervene, which is the order from Judge Sisitsky, which was entered in the Karen Reed case. That motion was brought by Mr. Bradle on behalf of Mr. Kearney, and Mr. Bradle, as I recall, wished to bring it with respect to both the Karen Reed case and with respect to this case. Judge Sisitsky announced at the outset that he was only there to deal with the Karen Reed case. He wasn't going to touch the Kearney case, but the language of the order prohibits all agents of the Commonwealth, which would seem to include me at the moment, Your Honor, from requires us to maintain the confidentiality, which is now essentially non-existent, not share, publish, disseminate, or otherwise disclose the data or any information concerning the data. So I may be partially to blame for this matter being before Your Honor this morning, because my position was, I'm happy to give it to you, but I don't want to get caught between an order on the criminal side telling me that I have to protect this information, not release it, not disclose it, and an order on the civil side saying, turn it over in response to the subpoena.
And this has already been produced by Mr. Kearney on his own?
That's my
correct, Your Honor.
understanding.
Yes,
Okay.
as a pro se non-party deponent.
All right. I'll take it under advisement.
Ooh.
Okay. Next motion. Paper 139, this was the issue of the items from the taint team. Anybody want to be heard on this?
Taint team.
Yes, I'd like to be.
Okay, I'll hear you.
Okay, so I think I'm gonna just stop for 1 second. I think it's interesting that he just didn't like say okay to whatever. Like he wants to look at that. Like very, very interesting.
I allowed it provisionally, but issued an order saying it couldn't be disseminated.
Right. The only thing I would say, Your Honor, is reading paper 134, which was the impounded report from Mr. Verino. It looks like some of the work has been completed, and there are two instances where he's looking for guidance from the court. That's the very last item, Apple iPhone A1549, and Apple iPhone on the next page, where he says the extraction attempt failed and he would need permission and in order to request an attempt by a law enforcement agency. I'm not sure how long it would take to accomplish those things. I haven't had an opportunity since, thanks to your honors allowing my motion. I've only had this now for a couple of days. I haven't had an opportunity to check with somebody with more sophistication than I in matters of electronics and extraction. Someone more sophisticated than I would probably be any 12-year-old I could stop on the street, but I don't really understand what this would involve and how long it would take and what the expense would be. So I'd like a little time to look into that. But with respect to what's already been done,
What's being proposed?
and it seems to be that they have, for example, the next to last entry, Honorable Macy reviewed and marked item for privilege. Working on producing the potential privilege data with notations by Honorable Macy, which I
Holy shit, that's right. In his phone, he wanted Meredith to be part of like the legal defense team. And then that would be like privileged communications. And she's like, I'm not fucking saying that. I'm not part of the defense team. But privilege is your lawyers. Okay. I'm curious if a paralegal would be included as well, because I think that Aidan Kearney had a lot of contact with the Courtney woman, right? And I would assume that would be part of the privilege. But if he fired her at any point in time, what about that? So again, there was a taint team because remember before Aidan Kearney was, let's see, it would be between the time of after he was arrested, then he is let back out, and then he has a device. But I didn't think that any of that stuff was taken. But nothing that's on his phone that he has client attorney privilege, but it does not include, like, he does not have client attorney privilege with like Karen's attorneys. So the taint team goes through and any emails or text messages, anything that has to do with client attorney privilege communications, like they can't be used against him. Like the prosecute, like nobody gets those.
items are deemed privileged for defense production. This was dated March 25th of 2026. This taint team process has been very laborious. And I would really like to get the ball rolling on this, or rolling a little further before we are up against the trial date.
How soon do you think, how long will it take you to formulate your position on further steps?
I don't think it will take me long at all, Your Honor. A week.
A week. Mr. Bettero, Mr. Bradel, you want to be heard on any of this?
Judge, I don't object to a week, if counsel wants to.
You have the materials he has, he's released to you.
Yes.
The report.
Yes.
Okay. So.
See, I wasn't even aware of that.
Well, that was the order that I issued.
Oh, you mean this?
No.
But.
No. Okay. So great question. So if Karen Reed, Alan Jackson, Trollboy were all in on the same communication, it's her privilege. No, you don't have client attorney privilege. Even Karen Reed wouldn't. So that's why your lawyers will always tell you, like, don't disclose what I have ever told you to anybody else. Once you do that, then you're waiving client attorney privilege. And that's going to really come up in some stuff that's down the road. And it's going to be some really good arguments on both sides to like really get into it. But I mean, Alan Jackson and David Iannetti were basically sharing strategy. Okay. Karen Reed is sharing trial strategy and with Aidan Kearney throughout their tenure of their, with the relationship. But that wouldn't be right there. If there was like, let's say like a 3-way chat, fuck no. None of that's protected. Because Aidan Kearney is not, sort of ways not being represented by any of those people. And if you want to include him in on whatever you're talking about, then you're basically foregoing any privilege that you would have in that communication of anything that would be said. For example, also, if you had like a dinner, whatever is said in a dinner, I mean, there's no privilege there. That's why lawyers will always listen. And they'll butt in and they'll be like, hey, no, don't say anything. So
Okay,
That was the order that I got, was to release that report.
right. But the text of the report says that they have the data, Macy's reviewed it or has reviewed some of it. I would like some indication to the team that we'd like to get it.
I don't know what exactly is in play here. Mr. Britt,
Yes, Judge.
you work with Mr. Cosgrove.
Okay, that's
You guys need to file a further motion to assist this process to speed it up. Just get it to me.
we would like to
I'll draft
receive it first.
something,
Yeah.
first to Mr. Bradle, and
Yeah, you guys can work. You
We'd
don't,
like to receive it first, though, Your Honor. I appreciate Commonwealth referenced this in their submission, that to the extent that there is a privileged notations in here, we'd like to see it first, to
Absolutely.
evaluate it.
understood. I get that part.
Okay.
All right, so look, get a report back to me 2 weeks from today, all right? And if you need a further court order to move the ball forward, I'd be glad to do that, all right? I assume you guys will come up with some agreement on it, right?
yeah, I
Mr. Bradle?
think it'll be a good.
Yes, Judge,
product.
I think, I propose to council that I'd just like to have it for, let's say, a week prior to the.
That's why I'll give you 2 weeks to sort this out.
All right,
All right?
appreciate it.
I suspect you don't need me to interfere with this.
I don't think so, Your Honor.
Yeah, my understanding may be less than a 12-year-old. Okay, last issue, which is the issue for disclosure on Proctor. Did you folks have some discussion about this?
Yes. We did, Your Honor. We're almost there.
All right.
I think we need court guidance on one disparity.
because there's going to be a Proctor issue. So I thought about that a long time ago, why Bettero would ever be like brought on to the Karen Reed case back in the day. Auntie Bev realized right away that it is a conflict of interest because he is representing Aidan Kearney. Okay. That is such a conflict. Basically, it would, I don't know if they wanted to do it to say like, hey, we can have an out with an appeal or something. That's the dumbest thing I've ever heard, that Mark Bettero would join Karen Reed's legal defense team back in the day. And Auntie Bev didn't let it happen, you know? And he was denied the pro hoc vice, like she didn't even give them an opportunity to like waive any conflict or something like that. There was a lot of things that were at the time, because that was like the second go round, they started sealing. And you're not, what Bev said is, Mr. Bettero, you want me to believe, I get that, you know, we all have our oaths and stuff like that, but you're going to be then in possession of material that nobody can see. Okay. Your client is Aidan Kearney. Okay. Nobody can use that material. It's sealed. So then you can't take the material that you see and then use it with anything to do with Aidan. I mean, it was loud. I mean, everyone's like, why couldn't Mark Bettero get on there? I'm just like, are you guys listening? What do you mean, why couldn't Mark Bettero get on there? Mark Bettero could have. He could have dropped Aidan Kearney as a client. But think about how fucking sneaky that they were trying to be to do that. And then Mark Bettero was like, I would never do that. And And she's like, there's just too many issues. Like too many problems could even happen. Then like Aidan's in your office and you're looking at something, or it's up and it's out and Like, come on. Like for those people to even think that was going to be allowed is absurd. Is fucking absurd. That's like asking your math teacher in 9th grade, hey, I'm going to go ahead and just take this fucking test that you already graded over here and use that key to go ahead and just do all my paper. Like what teacher's going to be like, yeah, you can just go ahead and do that. Like take the answer key and just go to town. Or, hey, do you need me and grade the papers, and I have a study hall second period, and then I have you on, third period. So you're gonna go ahead and grade tests, see what the answers are, and then take the test, at third period. Like that's what they're just, and people that don't understand that, just logic, like it's like playing a board game. No, you don't get to cheat. And no, we're not going to give you the opportunity to basically cheat or then give us appeals issues down the road because there's conflict here. Unbelievable.
It's very wide right now.
Idiots.
Far too wide. All right. I think I know where you can go. I'm not sure
we're not going to make you go through the labor of looking at our stuff.
All right. Tell you what. 2 weeks to give me a report on where you stand on that. All right. If you guys can reach an agreement, we will. That's fantastic.
Whoa!
All right. We're going to close the Zoom now. That's it. The Zoom is shut down.
Look at these idiots. Do you see these fucks? What trash cans? Look at these bastards. They're just fucking animals, man. This is honestly why the fuck I did not go to Boston or Massachusetts, okay? To be around this filth they're all fucking menaces, criminal motherfuckers. Okay? Unbelievable. Trash.
If you want to work it out, that's fantastic. If you still need more time to have this discussion, you want to come see
I've just never seen so much trash. This whole fucking Karen Reed is fucking supported. Like it's Trashville. I mean, he has brought ratchet fucking rude, no class motherfuckers.
even by Zoom, we can do that. If you guys have, again, if you guys reach an agreement, I'm not going to stand in the way. If you need further clarification after discussion, okay, tell me.
I was just hoping to gently push the Commonwealth today to put their position out, which we discussed prior to this hearing, and perhaps Your Honor can make the ruling. I think it's a pretty straightforward thing.
Tell me what you think I should know, Mr. President.
Essentially, I have folded my tent, so to speak, and agreed to provide information to Mr. Bradle to the same degree that has been provided in the other cases where there is Proctor discovered. And Mr. Bradle has agreed that essentially the same.
Dude, nobody has shown up for this man. Nobody lines the streets for this man. Do you know that he probably cries every fucking day about that? This little fucking man baby, cry baby. Because what a fucking gut punch daily. I think we can start asking ourselves if people were paid to be out there.
Protective order
during the Kearney case.
Which essentially boils down to that the materials provided will be provided only for the use of counsel and may be shown to the client. The client may not receive copies of those materials.
Is there any restriction on the use of those materials by the client? I think that's probably what we're circling around here.
Yes. That's my concern, and it seems to me that to the extent that the information, there's really two potential pieces of information. One is case-specific information, anything Mr. Proctor may have said relating to the specific case and Mr. Kearney.
That's would almost be automatic.
Sure, I would have no problem with that being shown to Mr. Kearney. However, it seems to me the bias information which is, as I understand it, a pretty standard. It's really the same for all defendants. The stuff's going back, whatever the comments that Mr. Proctor made about this person or that person that potentially could be used to impeach him if he is called as a witness and show bias that have nothing to do with Mr. Kearney in particular.
That's a visual prosecutor.
I don't wish to be shown. I would like to be restricted from showing to Mr. Kearney because I don't think that counsel needs his input if we come to trial to present a statement that Mr. Proctor made 12 years ago about a woman or minority or whatever. And the likelihood is it's only going to leak out into the internet to the extent it hasn't already. It's possible embarrassment.
Can you start back on the scale on people who say comments, inappropriate comments, unacceptable comments? It's going to open up things that we just don't necessarily need to come out. Those across that bridge, just a great comments. Mr. Brady, so what do you think?
This issue that the Commonwealth wants to sort of parse out is it's too vague to parse that out. I can't look at something and say, you know,
I'll give you 2 weeks.
it makes it adverse to the client, Your Honor, to have to
I'll give you 2 weeks to confirm. If you guys haven't come to an agreement by that, call Mr. Online.
Okay.
Come in and see me. It's a 15-minute hearing. It should not take us long. All right, so we've got 2 weeks on the issue of the contained team issue, and 2 weeks on this issue too.
Thank you, Your Honor. And then there's also a housekeeping issue relative to the dates, Your Honor, for trial and motions in May. I think we wanted to propose to the court. I think we hammered this out before you came out, which is that we wanted to propose Friday, December 4th for motions in limine, Monday, December 7th for trial and jury selection.
So I have another concern, Your Honor. I don't know that we need to resolve it today, but I want to put it on the court's radar, which is this is a Norfolk County case. Where is this trial?
Well, I'm here right now. Let's put it this way. Wherever it happens. Okay? That should satisfy any constitutional concerns.
I think that logistically, Plymouth Superior Court would be an excellent location.
Logistics, where it happens, is going to be a discussion which they have to have with their folks who are involved here.
Is it fair to
I
say,
appreciate that. I just wanted to put it on.
is it fair to say, Judge, that you'll know maybe in September when the next rotation comes through?
We'll have I'm in this room until the end of December.
Oh, okay.
So I'm assigned to Southern County
So you're
until
subject to
January
review.
of 2027. So the assumption is going to be with me, and the assumption is going to be in this room. We're going to have to make arrangements because this is a Norfolk County case. It's entitled to Norfolk County jurors unless he waives. And that would be my intention. Wherever this happens,
I'm going to discuss that with Mr. Kearney,
that it be tried in front of the Norfolk County jurors.
whether we waive it.
Well, Commonwealth gets something word on that as well. So
I had one other issue that I'd like to raise with Mr. Bradel. I don't need to ambush him, but I do want to bring it to the attention of the court. There has been, so far as I recall, and I don't think I've lost my memory to this extent yet, a motion to suppress with respect to the devices that were seized from Mr. Kearney pursuant to warrant. Some of them may not be usable, but we have at least the two cell phones which the search was conducted, and the fruits of that have been turned over to the defense. Defense has the motions. I don't want to get to a week before the day of the trial and
told that Your Honor needs to hear a motion to suppress.
If you're right into the cell phone, do you intend to use?
Oh, yes.
Folks need to have a discussion about this.
Well, I'm sure we will have a discussion about it in this ability. I'm just concerned about,
There may be an eliminate issue, Judge. We don't see any suppression issue.
All right, so there's no motion to suppress it. We'll deal with it as a motion to eliminate.
That's where we were going.
that's fine.
Wait a second. There's going to be no suppressions if we're going to treat it as a motion eliminate. Hold on one second. It's just, this is sucks for like the sound.
Be an eliminate issue, Judge. We don't see any.
Do you intend to use?
Oh, yes.
Folks need to have a discussion about this.
Well, I'm sure we will have a discussion about it in this ability. I'm just concerned about,
There may be an eliminate issue, Judge. We don't see any suppression issue.
All right, so there's no motion to suppress it. We'll deal with it as a motion to eliminate.
That's where we were going.
that's fine.
Here's what I suggest, folks. Someone, Aidan Kearney tells me I'm going to get a lot of motions to eliminate. So maybe we should go back another week on motions. Or at least take it to November the 30th, which is Monday before we'll bring in the afternoon. Deal with that. That gives us a full week to get decisions out and adjustments we made in the trial strategy.
Judge, can we go? Can I just confer 1 second?
Okay, so the big thing for me with Turtle Boy case that he needs to, if Cosgrove can use this 403B, he's in trouble. That's prior bad acts. So there's going to be they're going to attempt to do lots of motion in limines, meaning that you can't talk about certain things if it has no probative value. But Turtle Boy's gone on and on and on about his intent. I'm the only person that could talk about my intent.
Your Honor, we would like to avoid the Thanksgiving week. We're wondering if we could move it back to, say, the 19th or the 20th of November, for motions to eliminate.
That's a Thursday, Friday. 18th of November, we do our afternoon list on Mondays and Wednesdays, so to the extent we can stick with that.
18th, what about that, okay? Yes, that's fine.
So, any other schedule issues?
Could we maybe file those, so agree to file them like a week prior?
Those days on.
So 11th, out of court filing, November 11th.
My money. Okay, just one other matter. That's Veterans Day.
10th, whatever the closest date to that is.
So it's 12th. Take me another day.
12th. Sorry, 12th.
Okay, although the Zoom is now shut down, let me just send this message right now. The court is fine with Zoom. The court is perfectly happy to have the public observe and see the proceedings that are here today and going forward to observe the electronically observe the proceedings. But the court is not going to tolerate this commentary over the court's audio about people's thoughts. Happened 3 times. 3 times is all I need. I'm going to reopen the Zoom for the next hearing. If it happens just once, I'm going to shut the Zoom off, and that will be it for Zoom going forward. This is not a participatory experience for anyone but the parties. And the message I'm sure will get out to the various parties who'd like to listen and be broadcast. Zoom is a privilege, not a right. You don't get to participate in the hearings. Okay, anything else we can do today?
Just a little bit of clarification, Judge, on the dates. So once you have this right, November 12th, out of court, motion to eliminate service. November 18th, motion to eliminate, and that's 2 p.m., Mr. Clerk?
2 p.m.
And then December 4th, is that still a date, or are we off the calendar? Off the
Let's
calendar.
see.
December 7th, trial.
December 7th. I'll let folks look, we can be flexible. If you need to come back a second time, come back a second time. I'll make time for you, whatever needs to make time.
Thank you.
Okay?
And we may come back on the protective order in the next couple of
So
weeks.
the two outstanding matters, number one, motion to dismiss to decide. The other two issues, on tape team and on the proctor discovery, if you need further guidance from the court, let me know. Give me 2 weeks to try to sort it out. If you need me to decide, I'll be glad to decide. Anything else? Mr. Cosmo? Mr. Federer, Mr. Bradley?
Very good, Your Honor. Thank you.
All right, thank you very much for your arguments today.
Matters under advisement, the court set the following future court dates: November 18th, final pre-trial hearing at 2 p.m. with a trial, or 2 weeks later on December 7th at 9 a.m.
Wow.
All rise.
The idiot turtle riders were on that Zoom. You should be ashamed.
I agree. I agree, Mike. Idiots. Okay, so the proctor material they're talking about, I mean, I don't care. Proctor had nothing to do with it. There's no investigation here, guys. It's crazy. The victims are going to testify. They're going to use cell phone extractions and what he was, writing and saying to people, especially if he thinks he's testifying. Like everything that he wrote in text messages and I'm curious about Signal now. I'm curious if, oh man, I don't know. He needs to plea deal. He needs to move for a plea deal. Just press play, baby. Just press play. It's funny how bias is okay for some, but not for others. Yeah, just press play. Just press play. Dismissal will be denied. Oh, this is denied. 1000%. I think going on and on about Kate Peters is hilarious. The state, or the Commonwealth rather, is not calling Kate Peters to the stand. She's not a witness. Okay. To the extent of, if they want to call her to stand to say, you provided the courts with, think about that. Yep. No, the witnesses, the victims, you don't think that they were like saying like, this is what he's doing? Like, go look at this. Like, this is crazy. And he's recording himself doing it. And that's where you can find it. Everybody knew that he had some channel. I mean, it's like you guys think that Kate Peters was providing evidence that was like concealed from everybody else. No, it's on his live broadcasts. Like, there it is. I think it would be interesting to go back and examine, if you have a chance to go look at his, I don't know how much money they're spending on this, but his YouTube channel back end to see what he's edited, deleted. That 1000% would be there. It would tell you a ton of shit on the back end of your videos. It would tell you the views, when each view happened. They would tell you if you, let's say you made a video, it was public, right? And then you made it private. And then you decided 6 months later to, okay, let's make it, public again. They're going to be able to see that there was a gap there of like 3, 4, or 5 months where this video was not viewed by anybody. Okay. And then all of a sudden this video started being viewed again, right? He's been taking his own new like daily stuff that he does, and he's going back and he's showing his old stuff. I think that's just dumb for him to do that. I think that he should watch in private if he wants to do that, only because it could be seen as, I would think, is with his civil stuff, everything to do with his civil stuff, it's like you're re-victimizing, right? I don't know. And I would think criminally, yeah, sure. I don't know. And then half of these people, when they watch something, they think like they catch a video, or if he's alive and they show something, oh, is this happening now? Like maybe it would outrage people to go and do something to somebody. I don't know. He's a wild one. He's a wild one. I stand by my statements. If this man goes to if he has a jury trial, he is going to prison. He should be trying to cut a deal to get, like, I don't know, 10 years probation. But then I think that he would violate that. And then what? Because they're going to make him plead guilty to certain things and, plead guilty to this, we'll drop this. And then, we'll recommend that that you serve, it's like a suspended sentence and you're monitored. And if you break, here's your Karen Reed she couldn't do stuff after that trial for like a year or whatever. You can't do anything. I mean, I think he would get himself into trouble. And then, so if you violate that, then that's back on the table for your time. And I don't know. Yeah, that's so hard to have happen, that you're going to be found not guilty on all those charges. Like I said, Karen Reed wasn't found not guilty on everything because they applied the standard. If these people go back in their jury deliberating room and apply the standard, apply the statute, he's guilty on everything. He's guilty on everything. I think Cosgrove made a great statement when he says we don't have to. Aidan Kearney could have had 15 motives of why he did whatever. And he does. He has multiple motives of why he's going and doing something. We don't have to explain all of that. We can just show that one of them was this. So, yeah, well, you can say that your motive was hey, I did this because I was petitioning the government. Okay. Well, you don't also get to petition the government and witness intimidate. You don't get to also just claim that my activity was petitioning the government, right? And so therefore I can do whatever I want because I'm petitioning the government. And if you come across that way to a jury, I think I think that when you go back to a deliberating room and you're all talking and it's like, this guy just did what whatever he wanted. Did he affect the outcome of this case? Do you guys remember he said it himself? He's driving along in his car and he's like, I don't want this case to be like the O.J. Simpson case, like for Karen Reed, that she has this like asterisk next to her name, that. And I'm like, well, that's exactly what happened in this case. It's never going away. He harassed House defendants, end of story. Well, I say he harassed the Commonwealth witnesses. And I think that trial two, the first trial had all of these people in it. Trial two didn't have all of these people in it. I think to hear 10 people say that somebody didn't come into a house. I think when a jury goes back there and talks about that, so all 10 of these people are lying. Mary says he admits he's out to taint the jury and make the witnesses' lives miserable. Absolutely. Oh, I think That's why I can't believe that his attorneys, and maybe they are saying, Aidan, we have to try to get you a plea deal. I get that you want to take this and, but I'd be wanting it. Is there a break? Nope, it's over. It's getting denied. Did they say what county the trial will be in? I couldn't hear that. We got switched off from being on Zoom, which was perfect volume, to then we have to go do this fucking ratchet shit because the turtle riders act like assholes. The witnesses are suspects, says Benzo. Yeah. We don't get to decide that as citizens. It doesn't matter. Like, I think Karen Reed is hilarious for saying that in an interview. I can't believe that she was being asked about what Turtle Boy was doing, and she basically admits that he was witness harassing and intimidating. Like, what the fuck? That's some wild ass shit. Like, I think that both of them should have been quiet until all of this was behind them. I would have been scared to fuck with anything. You know what I mean? I'm not going to give anybody a chance to have something like, hey, it's not like, just certain things aren't worth it afterwards. Like, I was just acquitted, right? But Turtle Boy couldn't handle that, and Jesus, my God. Also, some witnesses were hesitant to testify. The witnesses said that they never seen the body. That's all the defense needed. They went overboard. Yeah, I would have turned in my own witnesses. And nobody was lying about that, right? People want to say, Juliana Nagel was because she saw like some blob or something like that, right? Well, the way that Turtle Boy made it seem is that Juliana Nagel like changed her story or something like that back in the day. That's not true at all. She was never interviewed. It's just his representation of the case was so wrong, and he was getting all of this shit wrong. And Karen and AJ and them were like correcting, how many corrections were made? No, I think they didn't see a body because, in my opinion, he wasn't there yet. Dude, if all these people were drinking and if they're a bunch of boozers, I don't know, man. I start questioning the, for Jennifer McCabe to continuing to call John O'Keefe on the phone, and whether they were like, because he wasn't arriving, I think that's pretty strong for her. The text messages, to sit here and say that Jennifer McCabe knew exactly, oh my God, I got to start texting and acting like he's not here and da-da-da-da. Like, that's some wild shit. That's what Aidan Kearney put out day one. He didn't even get a timeline. He didn't ask for anything. He just wasn't like, let's lay this out. He just fucking went on his own little, like, I just can never imagine if I was to say, hey, I'll help somebody out in a case, and I just, whatever they tell me, I just go ahead and do. I've never done that in my life, nor would I ever. I'm going to, hey, if you want my help, I'm going to need the material and I have to go through it. And then I'll show you what I think and point stuff out. And then when you're telling me stuff and it's just totally like fucking wild shit that had not jiving with any of this shit. And 9 times out of 10, it's usually like I'm the one that's pointing out to the people, like, and they're missing stuff and they're not connecting the dots right. And I just, oof. Woo. I would agree with that. You can't see something that you don't know is there. Why would anybody be paying attention to the lawn in a blizzard? Also, why would anybody be paying any attention to like over by like where the mulch area is, like a bed, I agree. And when you're drinking, I mean, why am I? Machado won't say anything. She's on to different stuff. She posted and said that she does not like Aiden and he is not a nice person. So there's that. I just think that all of this was not necessary. I think Karen Reed, there's hella reasonable doubt. You have all these experts, you know what I'm saying? And there were lots of talks about, you know what, I need to find that video. Fuck this, I'm going to find it. He was in his vehicle. He was on his way to maybe it was the May 3rd. Okay, maybe it's a fun. There's a. Let's see. God, this is backwards. He has a playlist that has 419 videos. Let's see. Throwaway Live. May 3rd, 2023. Let's see if I can pull that up like that. No, that's not going to work. Okay, hold on. How many minutes is that? 2 hours. If it's this day. Fuck. Okay, breaking. Karen Reed defense files motion to recuse Judge Canone and oppose gag order. Oh, it's close. So Karen Reed. I think it's called like my first court hearing. My first court hearing for Karen Reed. Karen Reed, Rule 17 hearing, defense team press conference and post court thoughts. We need the one that's before that. He's on his way. Okay, wait, no, Karen Reed. No. Let's go with this though. This post one might be. He probably dropped some shit in here.
I don't know how many of you were in there, but what just happened in that courtroom was a miscarriage. The Commonwealth is desperate not to get the facts out in front of the public. They're desperate not to have witnesses testify. They're desperate not to have witnesses have to answer questions. And it's because they don't have any facts to support their theory of the case. They're desperate not to have the hearing tomorrow, which is why they wanted it today, in order to basically sandbag everybody so that the press, thank God somebody was here to cover it, that the press and the public didn't see what happened. This was absolutely a travesty, and the Commonwealth has been at this, and they've constantly tried to have their foot on Karen Reed's throat from the beginning. It's becoming so obvious and so transparent, and it's not going to work. I can tell you this, it's not going to work. We're going to continue at this over and over and over. I hope to God that the judge sees her way clear to grant the Rule 17 motion. I think it's very obviously it's relevant. It's material evidence that we need, that Karen Reed is entitled to, constitutionally entitled to, and hopefully the court sees it that way. But the Commonwealth's conduct in springing witnesses on us at the last minute, coming into court, citing those witnesses, knowing that I was on an airplane when I got the report from this new witness that they produced this morning. Isn't that convenient? At some point, you start asking yourself, is it incompetence? And then at some point, it becomes complicity. And I think that's where we're at with the Commonwealth right now. It's just ridiculous.
Can you file anything to go about?
We're going to consider that. We're going to consider filing. What we're going to consider our options. We need to reconnoiter a little bit and talk about it. David and I are going to have that conversation along with the rest of our team, and Karen's going to have input on it as well. But look, there are certainly avenues that are available to us if we decide to go down that road.
Is that going to negatively impact your third-party theory going forward?
No. The third-party, look, it's not. The third-party culpability facts are not just a theory. They're facts. The facts that the Commonwealth can't get away from. They're going to come out now, or they're going to come out at trial. Our hope was to have these during the litigation so that it doesn't just happen. And ultimately, it doesn't affect our third-party culpability.
Okay, so right here, to sit here and say that there was no media there all that time, like that there's like, why isn't there any media here? Like, what the hell's going on? There was always media. This is his second court date. The first one that he goes to was this his, wait. Yeah, because he wore that fucking turtle suit.
Facts, because...
But you see, like, there's all this media, right?
The fact...
What's he doing?
Don't change. That's the beauty of a case like this. We don't have to run from the facts. How many of you folks have seen the defense going after the facts the way we are, and the Commonwealth, conversely, hiding from those facts? Rarely happens that way. There's something to that.
Who's frustrating you the most? Is it the judge? Is it the district attorney, prosecutors? Who are you upset about?
Well, I don't...
No, actually at the time, so this is now how I see it, looking back and redoing all of this. At the time, the state, or the prosecution isn't putting their case into the media, okay? And everything that they had up to that point is like, here's our case, like here you go. And it's like, those facts do not support Karen Reed. So we need to go out and find the facts that do, okay? So to sit here and say that, when is it ever that the defense is asking for this, that, and the other? Well, no, actually, you're trying to defend your client, and that's what we would expect you to do, right? But to sit here and say that the Commonwealth isn't the one that's looking for the facts, the Commonwealth is presenting, hey, this is what our case is here, then you guys are going to try to go out and do X, Y, and Z, right? So,
it's the process. The process that Karen Reed is having to suffer through right now is frustrating because she should be exonerated. What the Commonwealth should do is walk into the courtroom and say, you know what, we got it wrong. Mea culpa, we got it wrong. And we're going to go out and find the actual people who did this. That's.
And remember, this is all when you're trying to sit there and say that a Google search happened. Okay. It didn't happen. The 227 Google search did not happen. And this is what that all relied on, is that if that Google search happened, it's like, oh, look at Brian, Brian Albert and Brian Higgins. And, without that Google search, right. And it not happening.
What they should be doing. That's my frustration.
So is this a cover-up? And if so, who's leading the cover-up?
Your guess is as good as mine. That's what we're trying to figure out. That's
how. What do you mean? Who's leading the cover up? It would be the police that would be leading the cover up. It'd be the police that are even able to do that. It would start with the Canton Police Department because they were the first responders there. And at this point in time, when you go back and you look at the dates of this, what of the discovery did Karen Reed have? And that's why it's really important to consider what they had when they were talking like this. And this is one of the, you have to give them so much credit, right? And also realize what it was and be honest about it. But look there's media there. There's just not all these fucking people there.
exactly what we're trying to figure out. The
Who do you think it is?
Well, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved.
Do you guys remember all of this shit? There's a cover up. Like the Massachusetts State Police is involved. Why doesn't he say Canton? Canton Police. He goes Massachusetts State Police. And then it's Brian Albert is involved. Jen McCabe is involved.
The rest of the folks that were in that house, there's some level of involvement by every one of them.
There is some level of involvement by every one of them. Why hasn't Alan Jackson been sued?
Every single one of them.
And when you say involvement, like a man's dead, is that what you mean? Like,
until we're not going to rest until we get to the bottom of exactly who's behind this cover up, because not only Karen Reed deserves this, John O'Keefe deserves this, and has deserved this from moment one.
John O'Keefe deserved the investigation that went into this, but again, at the time, you have to think about this. It was like there's no dog running around like outside, right? Nobody's even saying anything about a dog. When does the talks of a dog even come out? You know? But I'm sorry, put the camera on David Yannetti. My client had no ill will here. No, there's no intent, criminal intent. My client did not have any criminal intent. And people want to say, well, that's when they were saying that there was evidence of it. I don't care if they were saying that there was evidence of it. You'd still be saying, I didn't fucking do shit. I didn't fucking hit him. I left. I don't care what the fuck they'd be saying. You would never be saying my client had no criminal intent. What? Well, then your client, that tells me that Karen Reed didn't remember anything. Because there's no way that David Yannetti is making those fucking statements. And I would be pissed. I would have fired him. I would have been like, what are you doing? Talking about that I had no criminal intent.
And that's why we're not going to rest.
Can you update us on the dog?
No, the court obviously ruled in our favor as well. She should have on the dog record information. The process now is that the court actually sends the summons to the record holders. We're waiting for that to happen. As soon as the court
So the court ruled in our favor, and we're gonna get the dog records.
sends that summons, then we will get the record.
Do you know where the dog is?
We don't yet. That's why we're seeking the records. Yeah, we have some suspicions, but we don't know.
Something you want to say?
No, Karen's not going to talk right now. Thank you.
No, Karen's not gonna talk right now. That's how it should have been. No, Karen's not gonna talk right now.
She just said something. I think she might have something she wants to say.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know.
Who the fuck is Steve? Steve, goddamn you. Look at this. Look at this.
Marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do. And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why do you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
That's what it's like. Was it a surprise with the motions to quash? How are you a Boston cop? You're not from Boston. Keep up the good work, man.
Thanks. Excuse me, sir. Just a moment. Aidan Kearney, Turtle Boy Daily News. Just have a couple questions for you. What's your name, sir? What's your name, sir? Are you a friend of John O'Keefe? Were you friends with John O'Keefe? Are you one of these people?
Okay, so that's how it happened. Holy shit. You know, he only just shows you that clip of him going up to the people. I never put 2 and 2 together because never watched it to look at it like this, but because of a person asking a question there, why'd she admit to it? She admit to it three or 4 times. That's what he asked Karen a question. He then fucking bulldogs to this person. Is that what an investigative journalist does? Like, wouldn't you say like, hey, I noticed that you asked Karen Reed some questions. Do you have any information? Like, what do you know? Who are you?
Who's involved in the cover-up? News. Just have a couple questions for you. What's your name, sir? What's your name, sir? Are you a friend of John O'Keefe? Were you friends with John O'Keefe? Are you one of these people who's involved in the cover-up? Which is nothing to say. Yeah, it's a lot to say back there. Hi, miss. What's your name, miss? Are you here to support justice for John O'Keefe or are you here to cover it up? Just out of curiosity, just wondering. Okay, we're doing it. We're doing it. So I noticed you guys back there.
And this is the tactics that they wanted employed. And this was Turtle Boy's job. Run off all these motherfuckers. We need somebody that's going to do like, I mean, but you see like at these court appearances, I mean, the media's there.
Said that you believe, why did Karen admit to it? You realize she asked a question, correct? According to their own testimony, that she asked a question, could I have done it? Do you think it's possible that Jen McCabe put that in her head? Are you guys friends with Jen McCabe? Who are you guys? Who are you guys? Why are you guys participating in the cover-up of the murder of a Boston?
Listen to this. This is absolutely fucking outrageous. That dude just simply asked, since Karen's standing there, you didn't admit to it? You didn't say that that you hit him? And Alan Jack's like, no, she didn't admit to it. She asked a question. It's difference. Okay. Like, but all he says is, why did you admit to it? And they're like, she didn't admit to it. And this is what he does.
Police officer. You guys participating in the cover-up.
Are you participating in the cover-up?
Of the murder of a Boston police officer. Are you a cop killer? Are you involved? Are you involved? Are you a police officer yourself, sir? We'll find out.
We're going to find out.
Media? No, that's not it.
What an app.
Oh, he's a veteran. Okay, so who are you, miss? You had a lot to say back there.
This is wild.
You had a lot to say back there.
What?
They got nothing to say now. You got very little to say now, folks. Very little to say now. All of a sudden, they got shy. They had a lot to say back there, but somebody actually, a real reporter, an award-winning journalist starts asking them questions. What do? They run away. They all run away. That's what they all do. Don't let that guy right there. That guy is helping to cover up a murder. He's a piece of shit.
He doesn't even know.
Do not let that guy walk around a polite society like he's some law-abiding citizen. He's not. He's a scumbag. He looked like a cop. Didn't he look like a cop? He had a lot to say back there, but he can't even say his goddamn name. What a joke. What an absolute joke. Miscarriage of justice. But karma's coming for you, baby. Karma's coming for you. So I believe that's the defense. It's a tough day for them, but justice will come. Justice will come. Literally the entirety of their whole argument is, oh, she said I did it. No, she asked the question. There's a big freaking difference. I shot the clerk. I shot the clerk. Never seen my cousin Vinny? I shot the clerk. I shot the clerk. What's happening, brother?
Really? Because Karen Reed does her own interviews and
so here we are, Senator Dedham. Justice was certainly not served today. This judge is a joke. She's part of the problem. Now, Adam Lally. So I interviewed Jen McCabe after court. I'm going to upload that video to YouTube. The YouTube stream was not working for some reason, so I got to do it here on Facebook. So we'll save this stream, though, and I'm going to go live, do a post stream on my way home about the injustice that happened a little more in detail. But I am going to upload the video of me confronting Jen McCabe and Adam Lally after court. So stay tuned for that, Turtle Riders, and we will see you guys all shortly. All right.
This is the one. Oh my God, this is the one.
What's up, everyone?
Yes, yes. I found it. I need a shot. What a fucking idiot.
All right. 12 people rolling in. Okay. So look at, I don't know what's going on YouTube.
12 people rolling in. Fucking hey, look at you guys. If this can be an exhibit. We got 12 people rolling in. You remember it was like 4 or 5?
All right. 12 people rolling in. Okay. So look at, I don't know what's going on YouTube. Like my phone got so hot that the phone shut down. I think I've never seen that before. It's an emergency. It shut down the phone because it got so hot. I don't know. Anyway.
Right there,
the phone shut down. I think I've never seen that before. It's an emergency.
He's got a phone there, and he's got a phone that's recording right now. At least 2 devices, 2 phones.
It shut down the phone because it got so hot. I don't know. Anyway.
Maybe it just died.
I think I'm right at like some TV. I'm in Needham right now. I think. Just got out of Canton. No, just got out of Dedham. I'm live on Clarence. If you're on YouTube, tell everyone there to come over to Clarence Woods Emerson. Anyway, so yeah, guys, I'm going to talk more in detail about this tonight on the live show, but today was not a good day for the defense at all, and for justice in general. I think we have a much better picture of what's going on here. And for justice in general, I think we have a much better picture of was not a good day for the defense at all. And for justice in general, I think we have a much better picture of
we have a much better picture
going on here. The judge denied or allowed Jennifer McCabe and Brian Albert's motion to quash the subpoena. They were both subpoenaed to testify at the evidentiary hearing tomorrow. And because Reddington and Greg Henning don't want to subject their clients to that because it would go horribly for them, they have
no, it's called like part of like law, like everything that he's doing now with like not wanting to turn over his phone. Like, no, I'm not like. But he wants to talk about karma, everything turning. Now he's in the position of like, why would I have to give you my stuff? I'm third party and
filed motions to quash the subpoenas, and they call it a fishing expedition. It's clearly not a fishing expedition.
Yeah, because they were seeking. If it wasn't a fishing expedition, they would have only been seeking very limited, like that day, that night, the 2 days or whatever. And they were allowed to get some stuff. So I don't think he's accurate there. But that's when Bev was like, in your one motion, you're saying this, and then you're saying these other dates here. Like, what are you seeking? It's all over the place. It's not consistent.
And the judge knows all this. It's just very clear at this point that the judge does not like, I mean, you can see it in her eyes. She does not like David Yannetti, and she really doesn't like Alan Jackson. And she even made a comment towards him at the end, like, you can just do this on Zoom. You don't always have to fly out here. Because they literally flew out here for the hearing tomorrow.
Can you see how he just spun that? I thought that was Bev being kind. Like, you can come on, like, you can appear via Zoom. Like, don't you think that's pretty kind? Look at how he spun this. What a fucking idiot.
Fly out here. Because they literally flew out here for the hearing tomorrow. And then while in the middle of their flight, they file a motion to cancel the hearing. I mean, how fucked up is that? I mean, this is the most blatant miscarriage of justice you'll ever see. Like, no other way around it. I think they were saying on the courthouse steps out, 30 years of law, they've never seen anything like this before. So the good news is, the good news is that the feds are on. Like, as soon as the feds start indicting, this is going to go away.
The good news is the feds are on. The feds are indicting. House long. House many years. Look at him talking about the Fed shit.
The good news is, the good news is that the feds are on. Like, as soon as the feds start indicting, this is going to go away. But until that happens, this is just more and more money for Karen Reed. Now, I'm not.
See, that's what this is about. It's just more and more money for Karen Reed. Money, money, money. This is when he starts really pushing this. It comes up. They launch at the end of May the defense fundraiser. Okay. So look at this foreshadowing here.
But until that happens, this is just more and more money for Karen Reed. Now, I'm not starting a GoFundMe. I don't do that. But if her attorneys start like a fund, I will definitely most certainly share it because, this is outrageous. Like, this whole thing today, you know how much money this cost Karen Reed today to do this? To fly all these people out here, get them hotels. Like, she has to pay for all that.
Why do you think that he's even talking about that? Think about that. You think that this man's mind is thinking about that? No. He was told about that. He was told to talk about that.
The forensic expert, Richard Green, is the one who determined that Jennifer McCabe Googled how...
Without doing any validation tests. To figure out what the fuck. Like, nothing.
long to die in cold is the one who determined that Jennifer McCabe Googled how long to die in cold at 2:27.
He didn't determine it.
7 a.m.
He pointed out the artifact that was in the Cellbrite. And it needed to be figured out what it was.
And the Commonwealth is saying that, well, that's not true. He's wrong. He made a mistake. She's actually doing this. They have now, okay, so where's your expert? This is like the perfect time to have an evidentiary hearing where you hear from both experts and they both make their case about why they are right. What are your credentials? Have you done murder cases before? Can you explain how this works?
Oh, that's so funny that you'd be mentioning this. So he's like, where's your expert? So you expect them to go out there and get an expert, right? Let's get the fucking date of this one more time. Again, see, May 24th. This is right when it's launched. The next live he does, he's launching it. Look at this. Legal defense for Turtle Boy against Julia. Julia Gulia. Julia Gulia. Okay.
And that would have obviously proven that this is all legitimate. Or, conversely, it could have proven for the prosecution that Rick Green is wrong. That would have been their chance to show. But they know that Rick Green is not wrong and that Rick Green is highly qualified and that the expert for the defense up until this point was State Trooper Nicholas Guarino, who, when he handed over the Celebrate data, a significant portion of it was missing. When he handed over the Celebrate data, a significant portion of it was missing. When he handed over the Celebrate data, a significant portion of it was missing.
Of who?
So he's not, I mean, he's not an expert. He's a state trooper. He's a detective. He would have gotten cross-examined and destroyed. He would have had no explanation for why all these deleted, like he couldn't find the deleted stuff. He gave him all the stuff that wasn't deleted, but the deleted stuff he couldn't find because he's not qualified to do that. He doesn't know what he's doing. So that's where Rick Green comes in. Rick Green is literally an expert from Sarasota, Florida, who was flown in for this hearing at the expense of Karen Reed and now will not get a chance to testify because they also filed a motion to cancel the hearing altogether, and they won that. They won that. I don't know if you guys were watching, if it was live streamed in court. They won that within 10 minutes of the hearing started. Greg Henning spoke first, and then David Yannetti spoke. And during David Yannetti's
supposed to be an evidentiary hearing
speech or whatever, she made it clear that she's allowing the motions to quash. No questions, whatever, just allowing it. And then they're like, okay, so now we're going to determine whether or not we're going to have the hearing tomorrow. And within 10 minutes, before Alan Jackson even got a chance to speak, she had already ruled that, well, the hearing's canceled. The hearing's just canceled. You got that? We're just not having a hearing. We have the common.
Why didn't Alan Jackson? Why didn't they put in? Why didn't they appeal that ruling? Turtle Boy. Why didn't they preserve the record and appeal that?
Commonwealth's entire argument here is that the Google searches, the person who did that, he's wrong. And instead of finding out whether or not this guy's right or wrong, the judge is just like, nope. And that's what a judge can do. And if you saw the way the judge was looking at like the facial expressions of not wanting to be there.
Okay, hey, who's from Mass in here? What highway is he on? In which direction is he heading?
When Alan Jackson and David Yannetti were talking, and the facial expressions that she had when Adam Lally was talking, it was like watching your kid at a recital. Like you're nervous for them. That's the way I would describe what she did. Like she looked nervous for Adam Lally, like she was rooting for him. Like, come on, you got this sport, you got this champ. You'll do your. He's
a body language expert. Oh my God.
Because she knows him. He's a hometown kid. They argue cases in front of her all the time. You can tell she does not like Karen Reed, Karen Reed's attorneys. And by the way, Karen Reed spoke today for the first time on the courthouse steps. And I think she was elegant and respectful. And
I think she was elegant and respectful, not like my journal writers.
Interrupted by a Boston police officer by the name of Carl Dougal, who we're going to go through our chat.
She wasn't interrupted. She wasn't interrupted. She had spoken. He asked the question after she had already spoken. I didn't see her. I think that Steve interrupted her. Karen, did you do it?
That's before. Carl has been sending me story ideas for quite some time. Carl's one of the only Boston police officers stupid enough.
So now he knows who the guy is? Before he didn't know when he was trying to figure out his license plate, and now all of a sudden he knows who that was. That would have come from Karen or the defense because he did not know. He had no idea who that was. Or was he acting like he didn't know? I don't think he knew.
To believe that Karen Reed did this. Like, people that are that fucking stupid should not be cops. Carl, you should not be a cop, dude. You're a fucking moron. Like, the fact that you are a police officer, that you're in charge of investigating crimes, is a threat to everyone's safety in Boston. You should hand in your badge and go sell insurance somewhere, because that's all you're fucking good for. You're a fake cop. You don't give a fuck about John O'Keefe. If you did, you'd be there on the side of the goddamn defense team. And by the way, you know who I was sitting next to in court today?
He'd be on the side of the defense team?
A young woman who happens to be the ex-girlfriend of John O'Keefe. I was sitting next to one of John O'Keefe's ex-girlfriends. She's on Karen's side. What does that tell you? What does that tell you?
Who? Bella's mom? Who? I'm just curious. Who is it?
They didn't know each other. I mean, logic would think like the ex-girlfriend of John O'Keefe would not like the next girlfriend that, you know, comes along. Like, logic would tell you that. Nobody ever likes the ex, you know, like that's not a thing. She's there with Karen Reed to support her. And they didn't even know each other before this all went down, because she's got a brain. She's not stupid, and all of you have brains. Everybody following this case knows what happened. Judge Cannoni knows what happened. Adam Lally knows what happens. And by the way, I confronted Adam Lally on my way into the Norfolk County Registry of Deeds, and I'm going to be uploading that video as well onto YouTube. Is the Jen McCabe video up? Have I don't know if you guys can. I can read the comments when they come up. Carl Dougal is his name, I believe. Yeah. Has the Jen McCabe confrontation video been uploaded to YouTube yet? Let me know in the comments if you've seen it already, because I do confront her.
He calls it a confrontation video, not an interview, not like a, you know, check out my confrontation video.
And Matt McCabe for about 2 minutes there. I accompany them to their car.
Whose water bottle is that? Where did that come from? That's fucking awesome.
And they sat across from me the whole time. They went and told the court officer on me. They snitched. They said, Mr. Court Officer, he's taking pictures of us. And the court officer came over and was like, there's no pictures of me. I'm not taking any pictures. I don't know what you're talking about. I got my phone out. I'm taking pictures. Maybe I was Googling how long to die in cold. Maybe I was reading about my kid's Ozone basketball team at that time. Maybe I was doing something like that. I don't know. I mean, talk about ironic. Talk about ironic. Haven't seen it yet, huh? Okay, so I don't know what the fuck's going on with YouTube, but that video, wait till you see the video of me confronting the McCabe's. Jen McCabe, I looked evil in the face today and I saw it. I looked evil in the face today and I saw it. The way she showed up, she was smiling the whole time. Like, just a cunt. Like, I cannot wait until they take Jen McCabe away to jail and her children are crying about it. And I can't wait for that.
This man is fucking sick, and he fucking has the balls to say, who the hell is rooting for me to go to prison and my kids and blah, 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 blah. Look at this fuck. May 24th, 2023. He is so fucked. So fucked. Dude, why do you have so much, like, this is some, like, wow, like, you would think that Jen McCabe did something to him. Wow. That's disgusting to say.
Reality, and her children are crying about it. And I can't wait for that reality to set in, the separation anxiety a mother will have from her kids.
The separation anxiety a mother will have. Where do you even think to say this? How does this even just come off your tongue, you fucking sick fuck? Talk about karma, man.
Gave away to jail, and her children are crying about it. And I can't wait for that reality to set in, the separation anxiety a mother will have from her kids. I can't wait for that. And she deserves it. She is pure evil.
That's your intent, motherfucker. That's your motives. Make sure you tip your bartender over here. This right here, dude's going down hard as fuck.
Poor kids. I mean, is pure evil. Her poor kids. I mean, all these poor kids being brought into this shit.
All these poor kids being brought into this shit. Are you fucking kidding me? He's saying this on May 24th. Do you know what happens here? Because of this video, okay? What does he do? Or I'm sorry, Jen actually goes and files for whatever at the end of May. He finds out about it because it got denied. June 5th, what's he doing? Him and his boyfriend are going and getting fake fucking names, fake fucking emails, and going to a kid's lacrosse game. Do you know what you would do to these kids by doing that and making a scene? He gives a fuck about nobody but himself.
I asked her about, the picture of, I actually asked Lally about this. You'll see. I go, well, how can you say that picture of Jen McCabe's kids is not her kids when we all know it's her kids? How can you say that? So I had my videographer there today. He had the whole thing afterwards, and Dateline was there as well. So Dateline was taking care of it all, and videographer there today. He had the whole thing afterwards, and Dateline was there as well. So Dateline was taking care of it all, and we'll see. We'll see what happens with Dateline, but this will be on Dateline. Like, this is going to be a Dateline episode.
And you weren't part of it, were you?
Guaranteed. And, there's only one reporter in town who's covering the real story behind this and the injustice that just took place in that court. Everyone with the brain knows that what we just saw, that Karen Reed didn't do this, and that they are now openly in court canceling evidentiary hearings, which they're entitled to, which would show that Karen Reed did not do this and that Jennifer McCabe and Brian Albert were involved. They are covering it up. At this point, I find it hard to believe the judge is just, in on it. I mean, that's ridiculous. But I think I've dealt with vindictive cunt judges. I mean, no offense to the ladies out there, but this is like that woman judge in Rhode Island. Remember her, Darrigan, that gave that issued an order against me twice with Ashley St. Angelo, a temporary. I mean, ridiculous. She was literally just like, yeah, I'm a cunt. This is what I'm doing. I don't like you, so I'm going to make your life difficult. That is what this judge is doing to Karen Reed. She doesn't like Alan Jackson and David Yannetti, and she's taking it out on Karen Reed. And
No, what she didn't appreciate was you guys doing your whole little, I'm going to leak it to Turtle Boy to write up an article, and then they're going to use that article to cite it in the court. Yeah. That whole thing that you were part of? Mm-hmm.
Hearing date for this is July something, like late July. And she's like, well, we could do September. And then she tells, what's his name? She tells Alan Jackson, oh, we can do, you can do it on Zoom, aka I don't like you in my courtroom. Stop complaining about your traveling costs. As if you can get effective representation in a murder trial via Zoom. Ridiculous. I mean, it's just unprofessional. I've never seen anything like this. But you know what, guys? There's a God. And, I don't know. I don't want to get too deep here. But God ain't going to allow this shit to happen, man. It's not going to happen. Karen Reed is being tested, and she's an extremely strong woman, as we saw in the courthouse steps today. And God is on her side, justice is on her side, the truth is on her side. And eventually she will be exonerated. The question is going to be, how long will she have to put up with this?
How long?
How much anxiety can a human being face?
How long?
And in the meantime, every minute wasted on this sham prosecution is time that could be used to go against and find the real people who did this. Like, it's absolutely, they're in the courtroom. Guys, the killers are in the courtroom. Matt McCabe, that fat fuck, that fat piece of shit, Matt McCabe, you cuck. Brian Albert's fucking your wife. How does that make you feel, asshole?
What?
We all know it. I mean, it's the worst kept secret in the world. Worst kept secret in the world. You cuck. You fat fuck with your belly there. I mean, they came dressed in blue jeans with Justice for JJ buttons. Oh my God. How do you look your daughters in the face? And by the way, I don't know if you know this, it is affecting your kids. I believe your daughter had a college roommate, right? What happened to that? I know a little bit about that. People don't want to be associated with your kids anymore. You understand this? God, you fucking people are despicable. Despicable. So I believe your daughter had a college roommate, right? What happened to that? I know a little bit about that. People don't want to be associated with your kids anymore. You understand this? God, you fucking people are despicable. Despicable. So I'm going to have a lot more to say. I'm going to write about this when I get home, guys. And I'm going to have a lot more to say on the live show tonight on YouTube. So make sure you subscribe to the YouTube channel. It should work fine when I'm at home. I'm guessing just my phone overheating or some shit. I have two. But we'll see you guys all tonight at 9 o'clock sharp for the live show. The Celtics are back. Dude, Celtics and last night was a must-win for the Heat. It really was. The more you think about it, because they don't want it, especially the way they lost big like that with the second half comeback. We have all the momentum now, and now we have all the excitement. I'm not going to say we're going to win, guaranteed to win tomorrow, but would you want to be the Heat tomorrow? I wouldn't want to be the Miami Heat tomorrow. In Boston, you win that. Now we're talking 3-2. We're going back to Miami. Talk about fucking pressure. Talk about pressure. They know if they lose game 6, it's done. It's a wrap. They ain't winning game 7 no fucking way. The pressure of being the first team to ever blow a 3-0 lead in NBA, basketball, it'd be crazy. It's happened in hockey. It's happened, obviously, to us, Bruins, and it's happened in baseball to us, the Red Sox, right?
Oh, the irony right now. To blow a story like this and take it too far that you end up getting arrested, felonies, the girl fucking gets acquitted, you lose everything and you go to fucking prison. The fucking irony. How do you blow a 3-0 lead?
But we could have the 3 greatest comebacks in football history. We've had the worst comeback in hockey history. Actually, the best comeback in hockey history was Game 7 against Toronto. That was the greatest comeback in NHL history.
This part is all freedom of speech until you get to the couple different things that he said. I mean, sort of can say whatever he wants. He can say, I fucking think Jen's a cunt. That's not, he didn't get arrested for that. It's not what he got arrested for. So, but you just don't get to say, hey, all of this right here was freedom of speech. His intentions, okay, because you have to you're going to put everything on a timeline. He says it right here about his intentions, that he wants the separation anxiety to occur between Jennifer McCabe getting arrested, okay, and the daughters. And I'm going to try to, do whatever I can to help make that happen, okay? And we'll just petition the government, right? Just petition them. If you petition the government, right, and you expose all the shit that they're doing and all this stuff allegedly, supposedly, right, just stick to them, and that they helped cover up for what you're saying. Prove that. do that. Stay right there, because then guess what? Then the results of that petitioning act will then result in what you want. But that's not what he did. He said that this wasn't happening basically fast enough. I'm going to do this on my own. I'm going to fucking do all this stuff to make all these people crumble. So they say, like, I don't want to testify, or I'm going to change in what I've already said, and I'm going to tell the truth, and I'm going to say, X, Y, and Z. I'm going to put this pressure on them. This is what witness intimidation. But the whole his civil shit, he's done right here. Because he's admitting right here that the thought for a kid that they would be separated from their mom going to jail would cause this, emotional shit. Yeah, and you're intentionally inflicting it upon them. Even if just the thought about that would happen, it's going to cause stuff. I mean, the stuff he's talking about, the one girl going to college and not having a roommate. And I mean, freedom of speech all fucking day. But you cross the line with, it's just, what are you doing? Why? You just have to ask why. And all for what? Somebody that was lying to you and couldn't even tell you about Higgy Bear? That had a fucking totally, like, just chap his motherfucking ass. But he did it all for money, so he didn't do it for fucking John O'Keefe. He didn't do it for Karen Reed. He didn't do any of this for anything about some, like, Martin Luther King-esque type shit. He did this for him. And so we'll just see how it all plays out. But this right here, this video, ooh, not good. But we found it. I had played it before, and the best part about the video is right here. When he says about...
All right. 12 people rolling in, okay.
12 people rolling in, okay, we're good to go. Like, and that should just show you that where he was, he wasn't making it. And he needed to do something outrageous, and because you're not making it being a YouTube creator with 7 people rolling in that should be like tuning in to your big, break here.
So look, I don't know what's going on YouTube. Like, my phone got so hot that the phone shut down. I think I've never seen that before. It said emergency. It shut down the phone because it got so hot. I don't know. Anyway.
All right, guys. Thanks for the 7 people that were watching. I appreciate you guys. Woosah. Till next time. Peace out. Yes, don't be hating. We agree to disagree, and it'll be interesting. It'll be interesting. He can freedom of speech it all the way up. All the way up. The phones are going to be interesting. He thinks that all these comments are out between all the messages between them. I know that they're not. I know that the most damaging messages, that's why he wants this stuff, because he can't even look at his own phone, he says. The most damaging messages that are in that man's phone, they have not hit the internet. So, and there's some really, really bad ones out there. So, till next time, peace.